Hello, everyone. Welcome back. My name is Ricky Bentley. I'm the program manager at Connecticut Land Conservation Council, or CLCC. We're the statewide umbrella organization for Connecticut's land trusts. CLCC supports Connecticut land trusts through advocacy, funding opportunities, technical assistance, and capacity building programs like this one. Today is the fourth installment of our seven-part Anatomy of a Land Transaction webinar series. This series provides a practical overview of the essential steps involved in successful conservation projects. If you're not already on our e-news list, I encourage you to sign up. It's the best way to stay informed about upcoming sessions and other events. Our session today is Boundary Matters, using surveys to protect your conservation interests. This session will provide land trust and conservation professionals with practical guidance on how to do a survey, what type of survey. So before we get started, just a few quick housekeeping notes. Please add your questions to the chat at any time. We'll have a dedicated time for Q&A at the end. If there's relevant questions, we can put them in, but otherwise we'll save them for the end. And to help preserve bandwidth, we ask that you remain muted and keep your video off until the discussion portion. And finally, this session is being recorded. We'll share the link out to our YouTube channel in the next few days. Now, I am pleased to introduce today's speaker, Steve Marien. Steve is a Connecticut licensed land surveyor and certified federal surveyor, is currently a CAD, GIS, and document control director at the Mohegan Tribe. He brings decades of experience in boundary determination, municipal permitting, and GIS management, along with extensive leadership as a CAD and project manager. Thanks for joining us today, Steve.
Thank you very much, Ricky. It's nice to be here. I'm glad to present to you today. I've compiled some information that I hope makes sense to all of you, and I hope that a few things that you can take away will be helpful to you moving forward. I'll also at the end, I think Ricky is going to put up my my course outline, or my webinar outline, so that you can download it if you need it. And also at the end of that, I have my contact information, my email address. So if anybody has any questions related to this, you could either reach out to Ricky or myself. Anything you think of after the webinar is done and you didn't get to ask. So I'd be glad to field questions. But here today, I'd like to start talking about surveys. I'm going to share my screen. So like that. Hopefully you can all see my screen. If you can't, Rick, you just have to let me know. But I'll assume that everybody can see my screen. So I am a licensed land surveyor. I'm also a certified federal surveyor. I've been working in Connecticut for my entire career. And my area of expertise is boundary determination, historic research, as it pertains to determining property lines. And I do a lot of expert witness testimony in court. And I like doing a lot of conservation work. So this is fun for me to do. I'm glad to be here to support conservation in the state of Connecticut. So I wanted to start off with some myths. You know, many of you may be already familiar with some of these things, but I wanted to point out a few things that over my couple of decades of land surveying, I've come to know that number one is the ancient record, the legal descriptions when I say ancient records, I mean early 1800s, 1700s. That's what I say. When I say ancient record, that's what I mean. So those legal descriptions are not as good as they are today. And the truth is that legal descriptions get much better when you get to the early 1800s and late 1700s, because land was much more valuable in terms of farming. And so for whatever reason, many people have different reasons for noting how legal descriptions got worse during the late 1800s and early 1900s. But to me, the ancient record is at least as good. Ancient surveyors, the old surveyors, were not as good as they are today. That is also not true. Land surveyors did very good work back then. They had bearings and distances on their surveys and quantified areas very well. And in most cases, when you get back into the old records, you will be able to find meets and bounds, descriptions with bearings and distances, like I said, in the late 1700s, early 1800s, and back. Another myth is that maps, stone walls, wire fences, iron pipes, that they convey properties, convey property, but they do not. Deeds convey property. So only a deed, if it calls for an iron pipe, it's the deed that conveys properties, the deed that creates property lines. And so the deeds are very important, are of primary importance in terms of determining where property lines are. And this is a very important principle. So I just wanted to point that out. Use of property you don't own cannot result in ownership. That is not true. If you've used property for a long time, more than 17 years in Connecticut, there is an opportunity for adverse possession, which I will discuss a little bit more further on. All surveys are equal. Over the years, I've had a statement that I make is that I've never had a problem with a survey until I've surveyed adjacent to another surveyor, because some surveyors do different will come up with a different determination than I do. So it is very important for me to work with my colleagues in the industry to make sure that our surveys are accurate. But surveys can be incorrect, and different surveyors can come up with different property lines. After all, a land surveyor gives a boundary opinion. We render an opinion as to where the property line is. The assessor's map shows the correct boundaries and areas. This is absolutely not correct. I would say the assessor's map, maybe 90% of the time, is very close. And sometimes it's really not good. It's really off. And that's if you use the assessor's map, you have to use that with caution. And the same goes for the GIS systems that these towns have now. Because the GIS system is based on the town assessor's maps. In addition to being careful using town GIS boundaries, you should also be careful about looking at the imagery that is associated with that, because often the imagery does not line up with the property line. So you might see a house through a property line, which is obviously most likely not going to be correct. So I think that's an important consideration. Size, acreage, and length of perimeter are the primary factors in determining the cost of a survey. They are factors, but all surveys are very different. And the biggest factor, in my opinion, is not the field work. The biggest factor is the research, land records research. The research can be easy. The research can be very difficult. And that makes the difference in a survey, in my opinion. The lowest bid is always the best value for a survey. I would say that if you've got two surveys that are Class A2 surveys for the same property, they're both Class A2 surveys. So from a legal standpoint, yes, they are equal, but it's important to make sure that the surveyor you hire does do good due diligence in order to come up with the correct property line. The property line is at the edge of pavement along a road. Some of you may I know a lot of people who think that they own up to the pavement, but you really, generally, that's not the case. Road right-of-ways, property lines along roads are usually 50 feet. Sometimes they're 2 rods, which is 33 feet, or 3 rods, 49.5 feet, or some other width. And this is especially true on state roads. So let me get into the next section here. Types of boundary or property surveys. So the most common certification is a Class A2 survey. And the Class A2 survey is the standard for an accurate survey that would be used for conveying property. It can be either a property survey or a perimeter survey. On smaller properties, land surveyors will often do a property survey, which is a survey of the entire property, including the interior, which may show where they would also take a survey of all the interior lands and include improvements, roadways, and other interior features. Whereas a perimeter survey, if it's a large piece of, say, 100 acres, the surveyor will look at just a strip of land around the perimeter to determine where the property lines are and make note of any encumbrances, rights of way, old roadways, and utilities, or anything that's along the perimeter, and they will not look on the interior of the property. This can be have some impact on a survey if there are cemeteries on the property, and most of the time cemeteries are not to be included in surveys. So if there's an interior cemetery that's overlooked, that could represent a parcel that is not included in a conveyance or a conveyance of the property. And then also access roadways, cart paths that go through underground utilities. There could be some easements or rights of way or encroachments that would be missed on the interior. So that is a concern for a perimeter survey. And then a type of survey that is not an accurate survey is a Class D. That's another very common survey. If a client doesn't want to pay a lot of money, they just need a picture for some specific purpose, they would get a Class D survey, and that's very easy for a land surveyor to do. They don't have to do any field work. They can just go gather some information and come up with, okay, this is what I found in the records, and this is what I think the property is based on that, but I'm not certifying to you that it is accurate. And this plan was compiled from other maps, record research, limited field measurements, and other sources of information, and is not to be construed as having been obtained as the result of a field survey, subject to such change as an accurate survey must disclose. A Class D survey should never be relied on for a conveyance. It should not be referenced in a deed, and you should not develop a legal description from a Class D map. That would be very risky to do. So moving on to the next section. So what does a survey tell you about a property? It provides a licensed land surveyor's opinion as to where the property lines are located on the ground. It usually involves field work and a map. And research, land records research. And all that data is compiled into a surveyor's opinion of where the property line's on. So it shows the property lines, obviously, with monumentation, dimensions, parcel area. It also shows any record easements. And when I say record easements, I mean easements that are documented in the land records. So in land records research, a land surveyor will follow the chain of title back and find any easements that this property may be subject to. They may be documented with an actual easement deed, and it may have an accompanying map that shows the dimensions of the easement or right-of-way or other encumbrance. And so those are found through examining the land records. And also a survey will include any discrepancies in the property lines um, that may be evident from the land records. So if you have a survey of an adjoining property and you research the property next door, you may find that your property line, after you apply the legal principles and all the evidence, that your property line differs from the other property line. So there may be a gap or an overlap in the property line. And I will show this on some of my examples at the end of this webinar, so you can see what I'm talking about on a few maps that I've done. So encroachments also are important when a surveyor does a property. And what an encroachment is where there is no record evidence of use of the subject property. So there's an old cart path that runs across the corner of this property, and the neighbor has been using that for 15 or 20 years. That the surveyor should make a note of that on the plan and quantify how much land is being used. And if they have any information, either word of mouth from the owner or from the adjacent landowner or anyone, they can include that as documentation. I think it's important to note that the land surveyor has to collect as much information as possible to put on the plan, so it's understood what problems may be, what encroachments might be on the property. So this may include lawns, other areas of improvements. Rarely there's a building, access to adjacent properties, utilities serving adjacent properties that may go over the subject property. Utility companies sometimes don't care, or they don't know where the property line's on. They don't bother to survey it. They'll just do the most practical thing to get a utility line to a residence or to another location. And they may overlook the fact that they're encroaching on another person's property. And then that becomes an encroachment because it's not documented. And encroachments can turn into prescriptive rights if it's used over a long period of time. So that's why it's important to document not only where these encroachments are, how long they've existed or been used, but not only where they are and how much land they are, but also how long they've been used. If that information is available, it should be gathered and put on the plan. So then there's adverse possession too. So, and this kind of is really an encroachment. So if there's an area of the subject parcel that is being used openly and notoriously by a neighbor, there's a number of criteria that the courts look at and that a judge would look at to determine if adverse possession applies. So beyond 15 years, if a neighbor can prove in the court of law that they've used it for more than 15 years, a judge may grant adverse possession. This is not easy, and they are somewhat rare, but they do happen. And I think the important thing to take away from this is that if there is adverse use or encroachments on a piece of property, the owner should be aware of those and aware that they could represent problems in the future. And I think from a stewardship standpoint, this is really important. If you have a piece of property that, especially if there's public funds being used to purchase this property for conservation, you really need to make sure those encroachments are resolved. And that's where legal counsel would come in. And that's where as it starts with the land surveyor on the boots on the ground, understanding what easements and encroachments and on the property are recorded and are documented appropriately and which ones are not. Because they can end up in lawsuits, and lawsuits, as we know, are not good for anybody. So very important consideration when hiring a surveyor is to make sure that they're collecting all that information. They are a land surveyor is a Class A2 survey that it requires them to look at these things. Okay, so I'll move on now to the survey process. So you can get a firm and fixed price or an estimate. So personally, I always like to give a firm and fixed price if I'm a clear scope, and a firm fixed price is what I prefer to do, because I think that my client needs to know how much it's going to cost. And since this is difficult to do, and a lot of surveyors do not like to give a firm fixed price, they like to give estimates, because it's very difficult to do a kind of an overview, a high level look at the project and determine what difficulties you're going to have once you get into the project. It's very difficult. So some projects go over budgets, some are under budget, and there's no way to tell upon starting the project what that's going to look like until you get into it. So you may get pushback from a surveyor on a firm fixed price. I always give a firm fixed price because I like my client to know. So the scope should be clear. It should clearly define that it's going to be a Class A2 survey, either a property survey or a perimeter survey. That the description of the parcels to be surveyed should be defined very clearly using the deed volume and page. And there could be multiple parcels in the deed, so being clear on which parcels are being surveyed in the deed is super important. I gave a proposal to someone. I think this happened twice, that I provided a proposal, and they owned 15 acres on this side of the street, and 40 or 50 acres on the other side of the street, and the problem was on the 15 acres, and I gave them a proposal for that. I did the survey, and they asked me, where's the other piece? And I said, well, the scope was very clear that it was just for this piece. So it's important that what is going to be surveyed is very clear in the scope. So you can reference the assessor's map, block, and lot, and the street address, but should not be the description of what is to be surveyed. It's just a general reference, because the assessor's information is sometimes not correct. So you should always include the deed description of the property that is going to be surveyed. I'm going to talk more about legal descriptions in a few minutes too. So that kind of dovetails into legal descriptions. And I also would recommend that you make sure that the survey includes an examination of the entire property, especially if it's a large property that may have improvements, utilities, cemeteries, traveled ways or roadways or cart paths that traverse the property. Oftentimes what happens is all the record research is done. A surveyor finds out that there's these particular easements and rights of way on the property. And when you're in the field, you find all those, and then you can check them off, as I have these recorded documents that correspond with the field conditions. But then you'll be in the field and you'll find that there is another right of way or another old road or another piece of land that is being used by an adjacent landowner that nobody knows about. And the first thing that a surveyor should do in that case is that what it does for me anyways, it sends me back to the land records to make sure I didn't miss anything. So I will go back to the land records and double check. And if I don't find it a second time, then I can say that this is an unrecorded right or potential encumbrance on the property that's unrecorded that has to be resolved in some way. And all these encumbrances should be surveyed, monumented, quantified in terms of area and location, and shown on the plan. This is very important. And this is part of the land surveyor's responsibility to the public, is to protect the rights and interests of the public. Okay, records research. So this is usually the first step in a surveyor that a surveyor will do, is to gather all the information necessary to make boundary line determinations. And as I said earlier, that deeds create property lines, maps do not. So the deeds are of primary importance. And so a title search has a number of goals for a land surveyor to help establish title to the subject parcel. So we need to know who owns the parcel, what the description of that is, and then we need to follow the title, the land title of that property back for an unspecified amount of time, to an unspecified period, because you need to research the property back far enough to know that have the deed that created each of those property lines, and you have consistent property lines between the adjoining properties, and that you have those deeds and copies of those important deeds so that you can make your boundary line determination. You also want to determine the locations and extent of encumbrances, any rights of way, easements that are in favor of the property and that the property may be subject to. So the property also may have rights of way over other properties or rights for utilities of some kind. So there's properties that are in favor of a subject parcel and that the subject parcel may be subject to. And all those should be quantified and shown on the plan and monumented. So when we establish a chain of title for the property, we also, it is common practice for a surveyor to research also the adjacent parcels and to match up those property lines and make sure that the descriptions are consistent and that we have a deed that gives geometry or tells you a location of the property, has monumentation that you can search for in the field to establish these property lines. If the deed calls for a pin in a boulder, your goal is to find that pin in the boulder. That is the property corner. Along a stone wall, along a wire fence, a concrete monument, a granite mirestone, anything that a distance off a building is also used. Anything that is called for in a deed as a monument to tell you where a property line or a property corner is a monument that must be found in the field. Okay, so we also review and collect all the survey plans that are on record. And it's most important to collect those maps that are referenced in deeds. If maps are done on properties, but they're not actually referenced in the deed, they are not nearly as important. When a map is referenced in a deed, you file a deed for a piece of property, and it gives you a description of the property, and it references being shown on this plan, and that plan is on file, then the plan becomes part of the deed. So that is very important to know, because then it becomes part of the legal description. If the map is not referenced, the map is not part of the deed, and it should not be used as primary evidence for the location of those property lines. Municipal utility records. Often we will have to go to towns, like the utility departments. They often have property line information, and they often have maps showing utility easements and where underground utilities are that may affect the property, and it's important. State maps, construction maps, taking maps for state roads and highways. If there's maps that are not on file, sometimes you know about a map and you have to go back to the land surveyor who did that to get a copy of it. And I think I already discussed how far back do we research. as far as is necessary to be comfortable that we've gotten all the information. It could be 1940, it could be 1740. And sometimes, and I'll show an example of this, where a property line, the only place we have an accurate description of this property line was in 1768. That's the only time that we have, and it was in the probate records in the state library. And I'll show an example of this in a little bit. So the field survey. All plans with modern technology, all plans should reference state plane coordinate system, which is currently NAT 83, North American datum, horizontal North American datum of 1983. GPS, almost all surveyors have GPS now, and have access to known monuments with known coordinates, that close to just about any site that they can use as for reference. And this is important because most towns, some of the organizations, conservation organizations, maybe most, have GIS. And if the surveys that you get are referenced to the state plane coordinate system, they can very easily be converted into geographic information system and put it in a database to be managed. And there's so much more you can do with GIS once you have that data in there. So they should all reference state plane North American datum. Property corners and angle points, angle point markers. Surveyors, most of surveyors use normal materials, iron pins, pipes. The one thing that I have a problem with is drill holes and stone walls, or boulders or whatever. Drill holes alone are very difficult to find. They have no metal, so even as a land surveyor, they can be difficult to find unless you know exactly where it is. Because oftentimes they're very shallow, they're in a stone, they're covered with moss, leaves, and they're in base stone. So a surveyor may get to a solid base stone, put a drill hole in, and then put stones back on top of it, and you have to tear the wall apart to find it. And that's problematic in my opinion. I would recommend that you make sure that if there are drill holes, that there is a steel nail, a substantial nail in the drill hole, wedged into a drill hole, so that it can be metal detected and found more easily. I do have some other standards here that when I set monuments in the woods, I always leave them a half a foot above grade so they can be found. If they're in a lawn area or an area where vehicles drive, or on an old cart path even, I will make them flush or even a little bit below grade so they don't get run over, and that they and then they can easily be found with a metal detector. Okay, so I went over stone walls. Concrete monuments are costly. Sometimes they're necessary if you really need to put a monument that is going to last a long time. Concrete monuments can be used. Computations. That's technical stuff. I won't bore you with that. Land surveyors usually have to make sure that their traverses close appropriately within a certain accuracy for a Class A2 survey, and that allows them to apply that A2 certification. So boundary determinations. So deeds create property lines, maps do not. As I stated, record evidence is deeds, maps, and probate records. Non-record or extrinsic evidence is evidence that's not recorded. In many cases, this information is needed, especially where there is no reliable primary evidence. So parole testimony, evidence of a right-of-way on the ground you have to locate. The records of another surveyor that did some work out there, never published a map that might have evidence of where a property line is. any monumentation, primarily monumentation that's called for in deeds. If we find monumentation that is not called for in deeds, but makes sense in terms of the dimensions and the geometry in the record, in the deeds, then a land surveyor has to make a determination if that makes sense or not. As I said, record documentation is a call in a deed that defines the location of a property line or a property corner. And that is primarily how the land surveyor should make property line determinations. Regarding public rights of way, town roads, state roads, and so forth, the Connecticut DOT, most state highways are monumented. Some of them are not, but most are. So it's often very easy to go to the state and get the documents you need to establish the state highway line. It's also important that, from a land surveyor standpoint, they may, some of the legal descriptions that they're using to try to reestablish property lines may go to the old road, which would not be the state highway line, but it would be a different line. And sometimes you can find out what those lines are from the construction plans of the state highway. So some of those records are also available and may be necessary. Town roads, most town roads resulted from very, very old pentways or farm roads or Indian trails. So finding the layout and acceptance of as a town road may be very difficult. Those are not in the land records generally. Sometimes they are, but they are usually accepted by town meetings. So in the old town meeting records, and those are very difficult and time consuming to look for. So land surveyors will usually look for other ways of establishing the street line. If there's a stone wall, the face of a stone wall on the roadside is generally considered the street line or the edge of the town right of way. And that is normally what a land surveyor will hold. If there are no stone walls, then sometimes surveyors will just assume a street line 25 feet off the center line, or they'll find out some other way to do it. But I feel I would normally try to find roads in the land records and find where they were laid out. This is particularly important where there's abandoned or discontinued roads in towns. If they bisect the property or along the edge of the property, the land surveyor needs to find how the road was laid out and how it was conveyed to the town, because that affects how an abandoned road reverts back to the adjacent landowners, whether it goes to the center line, whether it goes to the edge of the road, and so forth. So these can be important things to know because it impacts where the property lines are, and also what rights people may have over those abandoned or discontinued roadways. So survey plans, when you get a final survey plan, it should be clear so that a reasonably intelligent person without any knowledge of land surveying should be able to understand it. It should have a good legend. It should have clear notes with all the boundary decisions that the land surveyor made, reference to all the pertinent deeds and maps, a location map, a clear title, and all the text should be very clear and readable on the map. It should include all the information we've been talking about, rights of way, any roadways or improvements that may affect the property, easements, and so forth. And the map should be filed because a lot of times, many times, the state of Connecticut does not require a land surveyor to file all their maps. The filing is at the discretion of the client. So you do a map, they pay for it, you give the map to them. If they want to file the map, they can file the map, but they don't have to file the map. And that is somewhat problematic because a survey plan represents a snapshot in time of a property with all the conditions that existed at that time. And over time, those conditions change, those field conditions change. Pins get lost, stone walls get removed, things happen, and it's important for the next surveyor to understand what happened. It's a roadmap so that the future surveyors can follow in the footsteps of the original surveyor and perpetuate what was done in the past, and then apply what different conditions, both legal in the record as well as on the ground in the field take place. So I would encourage people who get surveys to file those maps. Okay, resolving conflicts and title issues. So we talked about if I find something in the field that doesn't look right, I need to expand my research and make sure I didn't miss anything. If there's a conflict in boundary and the descriptions disagree, there needs to be some legal action or some you either have to apply the law to determine which legal description takes precedence, and if that can't be done, then you need to get legal counsel involved. Conflicts between record property lines and lines of occupation. Those happen all the time. So, this guy, your neighbor, decides he wants his lawn a little bigger, doesn't know or care where the property lines are, and clears, half acre of land on an adjacent property. When I survey that adjacent property, I need to make a note that the owner has done that. And I can also look at aerials over time, and I can see perhaps how long that has been happening, because we look at that magic 15 years to determine whether there is some legitimate possible rights of adverse possession. Let's see. Unrecorded rights. Surveyor observes some unrecorded right. This will be clearly noted on the plan. We talked about that. Indeterminable boundaries. So in rare situations, there is not adequate evidence in the land records. I've never really come across that. I've only really come across that actually once, where there was no good legal description, where I was absolutely unable. I've exhausted all the resources and I did not have enough information to make that determination. I've always been able to rely on some extrinsic evidence by adjacent landowners, another survey professional, utility companies, and other agencies. I will have to exhaust all efforts to find out what the intent was for that property line. Parole testimony, which is the testimony of a person who has intimate and reliable knowledge of where the property line or corner is. So that can be used, usually it's used as corroborative evidence, but in certain cases, it can be used as primary evidence for determining where a property line is. Often surveyors will disagree about this, but it's often used where the legal descriptions are not clear. So boundary line agreement can be gotten. That's always a last resort. It works. And often the boundary line agreement is used when it would be too difficult to do the work, or people don't want to go to court. Let's just not go to court. Let's resolve it. I'll give you this boundary line. If we can get adjacent owners to agree on where it is, that can be done in order to avoid problems, avoid court. So that's an important consideration as well. So deliverables. Obviously, paper copies of the survey with the raised seal and signature of the land surveyor. Mylars, which have the appropriate seal so that they can be filed in the land records. And if you're a steward of land, you would probably want to keep a Mylar for yourself. Paper copies will fade. They'll get crunched up and wrinkled, and so you should have a nice hard a Mylar copy, which is a plastic with a permanent ink, so they're very durable. Copies, the digital files, so you should get some digital files too. So in digital files, you should get the AutoCAD drawing for it. If moving forward you ever need to do more work on that property, that your surveyor who did the original work is not around anymore, or doesn't have time to do the work, or doesn't want to do the work, you can give that CAD data to another surveyor And it will help save money because it's work that you've already paid for. If you need to expand that and upon that and do more work. GIS data. Now, in modern times, GIS is the digital format for sharing documentation, sharing information, geographic information to the public or to your colleagues in the business. So you may have a web application that consumes, that creates on your phone, just like GPS to navigate from one house to another. You know where you are on the ground, and it tells you where you are in relation to the property lines. Many of you may be familiar with this technology. It's a great technology, and it takes about 5 minutes for a land surveyor to create a shapefile from a CAD drawing of the exterior boundary, the polygon that creates the boundary line. So it's not a time-consuming thing, but it's something you should also have. A digital file containing all the points for the project. Those are, again, technical. All the points give you the coordinates of all the boundary points that can be also used in the future by a future technical person to do work on the property, a GIS professional or a land surveyor. Copies of the research chains of title, I would do that. And this is especially helpful if, and this is the case for a lot of conservation groups, they like to know the history of the property. So if I've researched a certain property back to 1750, when I have the chain of title complete back that far, it's often very good information for helping conservationists understand the history of the property. From a historical perspective, these can be interesting and valuable and important. Then a surveyor's report that gives a narrative of how the boundaries were determined, and any other items that are peculiar or unique to the particular property that's being surveyed. So with that, we have about, I was planning to end about 1 o'clock, so I think this is going to actually work out really well. So this is my contact information, and the document that Ricky said he sent up, he put up a link for that document. You can download it and has all this information on it. I'd like to pull up some maps. I'm going to pull up this map here and show you a few things on this particular map. This is a map I did a couple of years ago for the Nature Conservancy in Lebanon, Connecticut. They had a neighbor who was contesting this property line here. The assessor's map showed, hopefully you can all see this. So I'll maybe zoom up a little bit more so I can zoom up on this. So this property line was shown in the assessor's map. However, the adjacent landowner was claiming they own all this. So they hired me to research this property. So I did. And one thing to note right away is that I did, in fact, the land records and the deeds reveal that this property line is in fact the correct property line. The peculiar thing is that the only deed that defined this line with geometry, with the bearings and distances, was in about 1780. And I'm going to pull that up because I want to show it. I think it's indicative of why historic land records research is important. So TNC bought this property, and this is the subject property. And this is the description of it, which is north by Tobacco Street, east and south by Edward Stiles, and westerly by Lucy Congdon. And that description, I'm just following the chain of title back in my research, and I'm going back 1952, 47, 38, 37, and I still have just a basic description of this property, no bearings and distances, until we get to, this is 1855, still going back, and this is still only by landowners, and this is the portion of the property. And I'll quickly get back here, 15 acres, still, not much going on there in terms of the description of the property. So when we get back to this Nathaniel Loomis to Samuel Goodwin, right here, we find the legal description from Solomon Loomis to Noah Bliss actually has bearings and distances on it, and this says a straight line northeasterly. This is the line in question right here. And this is 1788, and we must go back further, one more deed to get to the original deed. We have to keep going back until we get to, I'm trying to get back to it. Hold on. Excuse me. State, I don't think I stopped here. I did not print it, but I have the probate record. And this is a 1768 will that's filed at the state library for this parcel of land. And this is the only document that has meets and bounds for that piece of land. I thought that was an important point to bring up, and that's why in some cases, the land records do not contain accurate information about where property lines are until you get into the ancient record. So I'll also show this property also had a situation where there are a number of maps, other surveys that overlap on this particular survey. In this case, legal counsel was notified, and they came out and they looked at it, and they determined that those maps were incorrect, and so they are not going to address it. But in other cases, these need to be addressed if there's overlaps and gaps, especially where public money is involved. This was a parcel that was already owned by the Nature Conservancy, so they didn't do anything about it. However, where public money is involved, there may be other considerations. This would have to be resolved before it's approved for conveyance or public money was allocated for a project like this, as you are probably well aware. So I can go look at another survey. I'll look at this survey. This is a survey I did for the Groton Open Space Association on Route 117 and Route 184. In this case, there's a small parcel here. There's a driveway that is on the actual subject parcel. So that was removed from the easement. And so they're not actually conveying it to the adjacent owner. That would be one way to resolve it, to cut this piece out and give it to the adjacent landowner. Then it's not an encumbrance on the property, and that resolves that legal issue for all parties. On this map also, that's the lower part. Let me go to the upper part. There's also was a well. The well actually was on the subject parcel. And so they conveyed a triangle of land to the adjacent landowner so that the well was on the parcel that it belonged to. These problems often come up, and they need to be resolved. So it's important. This is a situation where, as I went in the field, I located the well, and when I established the property line, the well was not on this land. And obviously the owner was pretty upset about that. So we took care of fixing that by conveying it to the landowner. He was very grateful, and it resolved our issue. There is another couple of encroachments here that are minor, a lawn encroachment and a lawn encroachment. Those were not addressed because they were not significant. I would also like to point out on this particular survey that this area here was very difficult to survey, and I had to research this back to a very early date. I had to research this back into the 1700s in order to determine where this property line is, and the gray is the area that I surveyed. And also I'm going to note another issue that came up is that there was a survey of this Candle Ridge Wood survey that followed a Class D map, the lines of a Class D map. The surveyor followed a Class D map that was on file, which is the incorrect thing to do. And really, after I did the research, I discovered that the property line actually was way down here. So we've discovered another title defect that resulted in an error of like 25 acres. And that's why it's important to have on properties that require historic research that the land surveyor is familiar with that, because it's not always in the recent title that property lines are established, or you can't render an accurate opinion and have the necessary evidence to create a property line, or to determine where the property lines are without going back as far as I did, which was again into the mid to early 1700s in order to figure out that this is a problem. I'm actually working on that survey right now. Another issue that we came up with was that there was an issue where the owner of this parcel had erroneously conveyed a portion right across the middle of the property to an adjacent landowner, and they didn't intend to do that. So, but it was done nevertheless. So we had to go back to the owner and get a quitclaim deed for this to resolve this particular issue as well. So there can be issues like this that arise. I'm not sure if there's anything else I had to show for that. I think I did want to show, here's a surveyor report that I did for this particular property. It gives a kind of an outline of what the surveyor did and how they came up with their boundary decisions and so forth. So that's an important document to have down the line in case there's questions when contracting a survey from a land surveyor. I think I'm all set. I think that concludes everything I wanted to cover.
Great. Thank you so much, Steve. So we can take some questions from the audience here. I see there's a couple we can start with in the chat.